Hello, everyone. I'm Kendall Smith with Thomson Reuters. Thank you so much to the National Association of Court Management for allowing us the opportunity to present to you all today. In today's session, we're going to be talking about evidence management and virtual hearings, and really how to address the challenge of sharing and submitting evidence during and after the COVID pandemic. Today's agenda includes an analysis of where we are right now in our challenging court system, what the challenges are that we've heard from our customers about evidence submission and sharing. We're then going to show you a real live mock hearing simulation so that you can see our solution in action. And then after, I'll be joined by my colleagues as we facilitate a roundtable discussion about best practices and in evidence sharing. Speaking of my colleagues, when we get to the roundtable session, we'll be joined by Mahesh Rangaswamy and David Jackson. Mahesh is a senior director with Thomson Reuters, who's focused on public safety, courts, and justice solutions internationally for the past 20 years, with a sharp focus on delivering integrated experience with technology and change solutions to improve access to justice. He's held leadership roles, including strategy, business development, operations, and client relationships for our court case management solutions, and is now focused on delivering virtual court solutions to the global market. David Jackson is also a senior director with Thomson Reuters. He is responsible for Caseline's business development, supporting courts, litigators, and prosecutors to manage virtual and physical hearings by preparing and delivering hearing files and presenting documentary and video evidence. Caselines has been delivering digital hearings since 2014 and is used by courts, prosecutors, lawyers, and general counsel for criminal, civil, child, and juvenile protection and tribunal cases in courts around the world, and for all criminal cases in England and Wales. Now, I mentioned we're going to have a mock hearing simulation in a little while, and then afterwards we'll have our roundtable discussion. But before doing that, I think it's important to take a step back and think about the situation that we've been in for the past, 7 or 8 months. Who would have thought at the beginning of 2020, we would be talking to you all about how to perform your court operations virtually? In my time in business development in the court industry, I've never seen technology step into the forefront as it has today to help courts really figure out a way to continue to deliver access to justice. Let's think about this for a minute. When we began, just a few short months ago, courts were very slow to adopt different technology and change. And the people and courts themselves viewed themselves as a place where justice happens. But that's now evolved. There's a new mindset. Courts are now seeing themselves as a public service independent of the location. They're looking for ways to continue to deliver access to justice and equitable outcomes, even in a remote environment. There's been a shift away from a reliance on paper-based processes and a shift towards finding ways to use digital technologies as a way to share more efficient information. And of course, we've seen now a rise in the increase in self-represented litigants. So how can courts really serve the needs of the public without creating additional technology barriers as they try to deliver access to justice? So with those challenges in mind, Thomson Reuters polled and met with many of our customers at the beginning of the pandemic. And repeatedly, over and over and over, they asked us, how can Thomson Reuters help us in the courts, judges and their staff, find more efficient and digital ways to submit and share evidence and exhibits, especially in today's virtual settings? So we were up for that challenge. We asked them, what are you doing today? And what are the challenges that you're having with those solutions? So many of them said, we're using paper, and now we can't have paper anymore because of the crisis. Some of them said they were having parties email documents to them in advance of hearings. Some were trying to use Dropbox as a way to have litigants post things to a Dropbox type repository. And oftentimes we saw courts using Zoom technologies and WebEx and Teams and doing screen shares, but none of those were really facilitating the efficient way to share and submit evidence. They named many, many issues along the way. First and foremost was security. Secondly was organizational structure. As documents were coming in via email or into Dropbox, there was no organizational structure to how those files are being submitted. File naming and versioning is an issue. File sizes are obviously an issue, especially as you get to larger video type files. And there was no way in these other means of document delivery to really include notes and annotations along the way. And ultimately, as judges are thinking about coming out of the pandemic and facilitating in-person hearings, there's the whole notion of juror access. How can a jury follow along and see what the evidence is that's been submitted without having to touch physical and potentially contaminated documents? So with those items in mind, Thomson Reuters made a decision, and we acquired a business called Caselines. We've now brought Caselines to the market called Thomson Reuters Evidence Sharing Platform, or ESP. It's a cloud-based system specifically built to allow case parties, court staff, and judges to securely share and collaborate on exhibits, evidence, and case documents to support virtual hearings while maintaining the integrity of an in-person court hearing. You'll see that the solution is secure, it's web-based, which allows access from anywhere, it's video conferencing system agnostic, and ultimately it provides collaborative, purpose-built presentation tools to allow the parties to mark up and present the evidence just like they would if they were in an in-person hearing. So before we start the simulation, I want to orient you with ultimately how evidence gets presented during a hearing. With ESP, the evidence is submitted in highly organized file folders that you see on the left-hand side of the screen. Parties, whether they're plaintiff, defendant, prosecutor, state's attorney, the court, witnesses, etc., all receive their own independent file folder where before the hearing they upload the information. Then, during the hearing, the parties can click to present the information to all of the parties that are connected through the platform. That's represented in the middle of the screen through the presentation area, where you can see in this example side-by-side documents that are under review or under submission to be considered by the court. And on the right-hand side of the screen is an annotation set, an annotation tray, where quick links and tags can be placed across the corpus of the evidence. And then that allows all of the parties to quickly navigate through to the relevant pieces of the evidence that are being presented during the hearing. So with that organizational structure in mind, where we organize, present, and annotate the evidence, let's now go watch Caselines in action in a mock hearing with Thomson Reuters Evidence Sharing Platform.
Hi. My name is Kendall Smith, and I'm the court coordinator for our virtual court. Today, we'll be demonstrating the Thomson Reuters Evidence Sharing Platform. It's a tool used by courts and case parties to securely submit and present evidence for hearings. The demonstration has 4 scenes. The first scene shows some of the pre-hearing tasks that court personnel perform to prepare for hearings. The second scene will show how parties to cases, such as the attorneys or any other parties, can upload evidence into their cases. The third scene will show how the judge prepares and then conducts a live hearing with the case parties wherein evidence is admitted. And the final scene will show how court staff manage the admitted evidence and schedule new hearings. So let's get started. As the court coordinator, I'll be demonstrating how our court users use the Thomson Reuters Evidence Sharing Platform to give case parties a secure, web-based way to submit and share evidence that will be presented during hearings. There are 2 tasks that I'll be showing today. The first is how to set up a case and sections in those cases where evidence will be uploaded. And the second will be inviting parties to upload their evidence. To get started, I go to the Thomson Reuters evidence sharing platform powered by Case Lines, and I log into the system. I click to view the case list, and the first thing that I want to do is create a brand new case and set up the sections in that case where evidence will be uploaded. To create a new case, I click the Create a Case button. I fill out some information about the case as I set it up. For example, the case name, and a reference number, also known as a case number. The front page allows me to customize a cover page for all of the evidence that will be admitted into the system. For my cover page, I'm going to copy and paste the case name and number. And then I'll scroll down to create this case shell. We now see that I have the Smith v. Jones Brother construction case created and some high-level information about that case. The next step that I want to complete is to create sections, also known as file holders, where the parties will start to upload their evidence. I'll click on Sections, and in my court, we set up sections for court files, plaintiff files, and defendant files. Court files might be a place where we place e-filings or copies of the pleadings that are part of the daily hearings. I've now created the court files section, and I want to create another one. The second section will be where I direct the plaintiffs to upload their evidence. And the last section will be this folder where I direct the defendants to upload their evidence or files. I've now created some case information and built out a list of the sections where evidence can be loaded by the parties. The next task that I want to show is how I can add a party to a case so that they can start uploading the evidence. I'm going to do that for a hearing we'll have later today in our virtual court. That hearing is in the Gypsy Rose case. So I'll find that case in the system, and I'll click to update it. Now the counsel that we're adding is a newly appointed counsel on the case, and he's just let me know that he needs access to the case so that he can upload the evidence that he'll be submitting in today's hearing. To add a new person into a case, I'll click the People tab. I can quickly see all of the current parties that have the ability to upload documents into the various sections within the Adoption of Gypsy Rose case. I want to invite a new participant. And in the email box, I'll find the person that I want to admit into this case so that they can upload their evidence. In this instance, I'm loading a new counsel by the name of Dave Johnson. I'll give him access to upload evidence into the master bundle and also set other security settings for this attorney. The last thing that I want to do is give Mr. Johnson an email notice that he's been added to the evidence sharing platform and a URL that will give him quick access to the specific section within this case that I want him to upload the evidence into. So you'll see in the invitation message, I can enter in the text that provides the proper instructions to each party. And I'll click invite. I've now completed the 2 tasks as part of the pre-hearing tasks that I wanted to show as part of the demonstration. Again, those included setting up a new case and the subsequent sections within that case where the evidence will be uploaded, whether it's court files, plaintiff files, or defendant files. And I've also shown how you can add people to an individual case so that that party or that person gets a personal email invite and is directed specifically to the file section where they should be submitting the evidence for any upcoming hearings. That concludes scene 1. We'll now transition to scene 2, where you'll watch Mr. Johnson, the newly appointed counsel in the case, review the email that he's received from me, and easily upload his evidence for presentation in today's hearing.
Hello, I'm Dave Johnson, attorney. I have just received an email from the court letting me know that I've been given access to a case that I was recently appointed on, and the hearing is later today. I know that I need to upload a file to that case prior to the hearing, and with the email that I've just received, I have the option to do so via the link that you see listed down below here on my screen. I'm simply going to click on that link, which will direct me straight to case lines and directly to the window where I need to upload that information. From here, I'm simply going to open up my Explorer window, locate the file that I need to upload, and simply drag and drop that file into the Select Files window. Once that's done, all I have to do is simply click on the Start Upload button, and when I do so, you'll notice that it runs a quick virus scan on that file. I'm going to go ahead and click Start Upload. There's our virus scan. And with that done, I have now just uploaded my file for the hearing today, and I'm prepared for that particular session.
Good morning. I'm the judge of this virtual court, and I need to prepare for today's hearing by reviewing the case notes that I took last time when I met with the parties. In order to do this, I'm going to first start with sharing my screen and logging into the evidence sharing platform. To do that, I press on the log on button and I enter my username and password as such. And that brings me to the search screen where I can easily locate the case that I'm looking for. Today, I'm interested in looking at a very specific case with respect to the adoption of Gypsy Rose that I'm going to be hearing. And I would like to take a look at the notes that I prepared. In order to do that, I'm going to click on Update Case to look at the case details and look at the notes that I took during my previous sessions with respect to this particular case. Now that I've had an opportunity to take a look at the notes on this case, I believe I'm ready to go into the hearing. In order to go into the hearing, I can click on Case Home, and I notice that there is a hearing conference link that I can access launching the Zoom hearing. That is typically how I access my virtual hearings.
Now that the judge has prepared for the upcoming hearing, we'll now see what happens during an actual virtual hearing.
Good morning. We are here to review the case of Gypsy Rose. The case has been brought by the state. Can I check to make sure that all are present and see the screen that I am sharing? Who is here for the state?
Joe Pelton for the state, Your Honor. And yes, we can see your screen.
Thank you,
Dave
Mr. Pelton. Who is here for the parents?
Dave Johnson, representing the parents, Your Honor.
Okay. I note that you have just filed your appearance in this case. Did you have time to submit the required evidence today, Mr. Johnson?
Yes, I did, Your Honor.
Okay, my court coordinator, Ms. Smith, is going to be recording all the proceedings and managing the admitted evidence. Now let's go ahead and get started. Mr. Pelton, as I recall from my notes from our last hearing, you were collecting evidence to present to argue against the adoption. I can see you have done a lot of work, but now that you have uploaded so many documents, it is not very clear where you would like me to look. So I would like to first go look at the evidence that you have submitted, and if you could guide me, please.
Yes, Your Honor, I apologize. If I may, I'll take you to the important documents. I'd like to start by referring to the leading case on B2 in the matter of parental rights, and I'll direct you there to the citation on B3, page 2. I can page direct you there if you'll allow.
Yes, Mr. Pelton, thank you. I see that you're also logged into the evidence sharing platform and you're able to direct me. Thank you. I'm going to now go to the matter that you're looking to discuss here. Yes, I see. Is there anything else you'd like to add here, Mr. Pelton?
Your Honor, if you'd like, you can click on the hyperlink to go through to Westlaw.
Thank you, Mr. Pelton. I will make a note at this point of time because I don't want to take the court's time to do this. I will add a note here to I will make this a private note and I will review it at a later point in time.
Thank you, Your Honor. I also have a photo of the living conditions in the parents' house yesterday, which you can see under the state's evidence.
Thank you, Mr. Pelton. I see that there's several files here and there is a photo of the living conditions that has been included within here. And yes, I do see the photo here.
Objection, Your Honor. If you look at the metadata on that file, you'll see that that photo was taken, I believe, in 2012.
Let me take a look at the metadata for this file, Mr. Johnson. I can click on view and go to display metadata. I see that there is metadata with respect to this photograph. And I feel that this is indeed a correct photograph. Any other questions, Mr. Johnson?
No, sir.
Okay, with that, what I'm going to do is I'm going to admit this photograph as an exhibit and admit it into the court file. Thank you. Counsel, Mr. Pelton, anything else?
Yes, Your Honor, thank you. I'd now like to submit into evidence a video recording of the child's interview, which has also been uploaded under the state's evidence. And to assist the court, I've placed a note within the video directing you to the moment where custody is discussed. You can view that note in the annotations window on your right.
I see that. I see that you have added a note which directs me to go to media on the 22nd mark. So let me take a look at that. And yes, there is this note. I was able to take a look at this video in my chambers prior to this hearing in preparation for it. I do not want to waste the court's time doing that at this point in time. If the counsel for the parents has no issues, I would like to admit this into evidence as well.
We have no objections, Your Honor.
Thank you, Mr. Johnson. I will admit this into evidence now at this point of time. All right, now I'd like to switch over to the counsel for the parents. Is there anything you would like to add, Mr. Johnson?
Your Honor, as you know, I was just added to the case today, but as I mentioned earlier, I was able to upload a witness statement to the record. I would now like to call the witness to the stand, if that's okay, Your Honor. And if you'd like, I can direct you to that statement as well.
Very well. Court coordinator, please admit the witness. Witness, Mr. Brian Burke, I believe is your name?
Yes, sir. Yes, Your Honor.
Please raise your right hand. Do you swear that the testimony that you're about to give is true and correct?
Yes, Your Honor.
Mr. Johnson.
Mr. Burke, you should be able to see the witness statement that you submitted to the court earlier. I just want you to attest that that is, in fact, your statement and your signature at the bottom of the page.
It is, Mr. Johnson.
Good. Your Honor, we'd like to submit this as evidence to the record.
If there are no objections from the state, I will go ahead and do that.
No objections.
Thank you. The evidence has been admitted. Anything further, Mr. Johnson?
Nothing further, Your Honor.
Okay, then with this newly added evidence, I will now recess the hearing and return to my chambers to conduct my final reviews and render a decision. I will set this case for a final decision on the adoption in the next available court date that my court coordinator will take care of. Ms. Smith, please download the evidence bundle and follow due process to submit into the case record. Thank you very much. All adjourned.
Now that the hearing's concluded, I need to close out 2 remaining tasks before my day is done. The first is to download the admitted evidence bundle, process that, and send it over to our docketing group so they can put it into our case management system. The second task is to schedule the next hearing in this case so that the judge can render his decision. To download the bundle, I'll find the case that we just had the hearing in, and I'll click to update the case. I'll click on Bundles, and I can see that there's a master bundle of evidence that's now been admitted, and I'll click to download. The evidence is placed into a PDF packet. I'll open the PDF, and I can see the index page that's been applied to the bundle of evidence, an index that contains a categorized listing of every section and the subsequent evidence that was uploaded from that section, and then the corresponding sets of evidence that have been admitted. And again, I can download or print and email this information over to our docketing department so that it can be uploaded into our case management system. Now that I've downloaded the bundle of evidence, I'll move on to the last task, which is to set the next hearing date. I'll click on Case Home, scroll down to view the hearings information, and I'll add the next hearing. I simply select the next date, the time, and if this next hearing will be conducted via video conferencing, I can add the URL for whatever video conferencing tool we use within our court. That way, all of the parties can click the video conference link and quickly access the session. We walked through the 4 scenarios today as part of our demonstration. Again, you saw how a court coordinator or a court clerk could set up new cases and designate different sections within those cases that the parties would upload evidence. You saw how counsel or any litigant can follow an email URL to securely upload evidence to the designated sections. You saw how the judge can review case notes to refresh or remind themselves on information that's relevant before starting the hearing. And you saw a live hearing in action where parties presented and directed all parties to the evidence folders that was being presented to the judge. And lastly, you saw how that evidence was file stamped and admitted into the record. When closing out the hearing, you saw how the court coordinator can download the admitted evidence from the hearings and send it off to case processing, and lastly, how to set up a subsequent hearing. We hope you've enjoyed our demonstration of the evidence sharing platform today and how you can use this platform to securely submit and present evidence in virtual and physical hearings. Thank you for your time.
Great. So I hope with that backdrop in mind of the mock hearing, we'll now open it up to our roundtable, where I'm now going to introduce my colleagues, Mahesh Rangaswamy and David Jackson. Welcome, gentlemen, to our roundtable today.
Thank you. Thank you, Kendall.
I do want to remind our audience that at this point, if you'd like to chat in questions, we can take those live. And also any that we don't get to, we'll be sure to follow up after today's webinar as well. But feel free to use the chat box to send those in, and we'll be monitoring those. What an exciting time, right, guys? Here we are at Thomson Reuters, really helping our customers in real time deal with how to manage virtual and even digital hearings as people now go back to real life courtroom scenarios. So some of the questions I know that we want to talk about and that I'm sure that our audience is interested in hearing is where all is the evidence sharing platform currently in place? So, David, I know, since you've been with Caselines now for so long, why don't you start with sort of an international view of where all the ESP platform is being utilized?
Good day, Kendall. I'm glad to do so. So I think let's start with the United Kingdom, where the Caselines platform has been delivering the entire criminal justice system since 2015. And then other countries in South Africa, for instance, the system is being rolled out for all civil courts in the entire country. More recently in Ontario, we started in July of this year and are in midway through a rollout for the entire province of Ontario. And then finally in California, the system has been picked up, very interesting case, for all of the administrative hearings by the Office of Administrative Hearings. That system went live in May and is going very, very well.
Now, that's great, David. And what I wanted to also highlight is as we've entered into the US market here, we're seeing a lot of interest from our trial court customers as well. And very recently, we were able to implement Caselines for a county in Pennsylvania, Lackawanna County. And interestingly, Lackawanna County is going to be utilizing the solution to manage their physical hearings. So if you think about it, the concept of digitization really spans across whether you're doing it from a virtual perspective or you're doing it from a physical standpoint. So that's been a great experience so far. And we're also running a number of different pilots in the United States right now that are showing very positive results. Back over to you, Kendall.
Yeah, that's right. I'm glad you mentioned kind of the digital aspect of this. So, David, it's important, I think, for our audience to understand that while we in the U.S. really took advantage of the pandemic to implement digital solutions, Caselines was actually not implemented just for virtual hearings. It was actually created as a way to facilitate more efficient digital proceedings in the physical sense. So can you talk about that a little bit in the UK and how the system has been used to make in-person proceedings more efficient?
Sure. Yes, you're absolutely right. We designed the system originally to drive efficiencies in the courtroom and for the parties bringing cases. So what we've seen is courts deliver very significant savings in time. Hearings proceed more quickly during the courtroom, during the day. Some lawyers say they save 10%, 20% even of the time that they would otherwise have set aside for a hearing. Judges in particular like the ability to get through a list very quickly. In England, the courts cut out a number of the normal processes as a result of being able to digitize, and that saved significant amounts of effort. And I sat with one judge who visited England from Canada a couple of years ago, and she was invited by a criminal judge in England to sit on the bench as a guest with her, which is very unusual. And she really enjoyed it. Afterwards, she said that if she had had the system in her own courthouse, she would have cut the time to do a typical list by 50%. So we get huge savings coming through. And at one time, when we first went live with this, we also used to count the number of pages saved and the amount of trees that no longer got chopped down. And one of my customers in the UK counted after a while that if they had sellotaped together all of the paper that they had saved, they could make a strip of paper that would go to the moon, round the moon and back 3 times in a row. By that point, we figured we might as well stop counting. We were making big savings.
Oh, that's interesting. That's a great little analogy. I'm going to use that to the moon and back. Mahesh, I think as we bring ESP into the US market, do you see certain case types or applicability in the US courts that are more prone or more receptive to using the platform for evidence sharing?
Great question, Kendall. And the solution is structured in such a way that it is agnostic to the case type. And if you look at how our trial courts operate today, pretty much any case that comes into the courtroom that has evidentiary material, paper that is coming in that needs to be considered as part of a hearing or as part of concluding a case becomes an ideal candidate for a solution like Caselines, where evidence can be shared and collaborated upon very well. And from criminal to family
to child support cases, we're seeing applicability across the board in terms of how the solution can add value, number one, bring transparency to the courts, and also create the collaborative environment where everyone is singing from the same sheet of music. So there is no specific case type where the applicability of ESP is better than the other. We see this as an efficiency mechanism across all the different case types, pretty much across all 50 states and administrative hearing offices.
Mm-hmm. That's great. So I know that our audience is probably anxious to learn more about the security aspects of case lines, knowing that some of the traditional means of sharing and submitting evidence, have been fraught with security issues, whether it's email or Dropbox or the share screen scenarios. So, David, do you want to walk us through the security aspects of the platform?
Sure, yes, of course. It is a highly secure platform, and you can imagine that it has to be. It's being used by the British government, and other governments have been looking at the system and tested us out. We've had people independently review our code to make sure that the whole thing is completely safe. In the US, one of the things that we focused on is being CJIS compliant so that law enforcement criminal evidence data can be passed through the system. And that's a big deal, as you can imagine. We now run in the Microsoft Azure FedRAMP data center. It's called the GovCloud, which is a highly secure environment suitable for this sort of information. And we are secure and certified to different standards. The key one is called ISO 27001, but we produce a SOC 2 audit. We have independent reviews of our CJIS compliance, and we also have annual penetration testing by external bodies who attempt to hack into our system and let us know if they find any difficulty, any vulnerability that we need to fix. So it's secure and something that we're committed to maintaining. It's interesting because during this whole process of courts responding to COVID-19, what we found is that many courts have tried to respond quickly by using off-the-shelf products. Well, we all know them. It's unfair to name particular products, but basically file sharing apps in the cloud and also sharing documents by email. And I think many of them now beginning to realize that those tools, which were useful in a crisis, really don't stack up in the long run. They're not particularly efficient, but more importantly for many courts, they're not actually secure enough. They don't meet the criminal justice information system security protocol standards. There aren't audit trails. You can't necessarily be sure what's happened to a document once somebody has been given access to it and downloaded it. Anything that goes with an email in clear email is potentially hackable. So courts are coming around to the view that those short-term solutions really may not have been good enough, and that people need to think about longer-term solutions that are designed with security at the heart of the solution.
Mm-hmm. What about how does the platform address the security around the individual sections themselves? So if I am putting together my bundle of evidence, when is it that the opposing party or the judge has access to those?
Well, a lot of that depends on your local protocols. So courts have a lot of flexibility about how they wish to implement and set up the system. But key to it all is the requirement that each individual is invited to a specific case. So we don't have group permissions with hundreds of different users all able to access different cases. Every single case has to be accessed as a result of a single person making a decision to invite you or me into that case and give us access. But then we can also be much more granular. We can decide that when I, for instance, give you, Kendall, permission to access a document, I can choose that you only see pages 1 to 3 of that document. I might say that you can only see documents A and B, but not document C in a file. And I can also decide if there have been some redactions applied. So we've had to take out social security numbers, license plates, addresses of key individuals. If the documents have been redacted, when I give you permission to see it, I can choose whether you're allowed to see the redactions or not. And even at that level, I can choose different redactions. I can say that you're allowed to see all documents apart from personally identifiable information, such as medical information, or I can say, no, you can not see anything that is attorney privileged. So it's a very, very granular security model.
Yep, great, thanks. So I'm thinking, Mahesh, as you know, more and more courts are now implementing the evidence sharing platform into their daily routine and their court operations. What are some of the best practices that we are taking forward and that we're seeing come out of those implementations?
Definitely, Kendall. It's some very good learnings for us, and obviously David and the team have brought a lot of learnings from UK and other countries. But as we're starting to roll this out in our US geography and the Canadian geography, where it is very similar in terms of practice of law, the big thing is simplicity, right? When you look at the capability that our Caseline Solutions provides when it comes to evidence sharing, one of the biggest things that we highlight and we keep repeating to our customers is let's make it simple in terms of providing the facility to the users, whether it's prosecutors or to the external law firms or to the self-represented litigants, make that interaction extremely simple, because it is as simple as what we saw in the demo a little while ago. It's about uploading a document. It's as simple as that. So that's one thing that I would highlight in terms of that simplicity. The second thing is for the courts to think about, how do you want to roll this into your existing business practices? You already have a motion that you are following, whether it's with prosecution or with the law firms. How do you bring in the evidence sharing capability in line with your existing business practices and business processes so that you're not overwhelming the end users? In Ontario, for instance, they've made the interaction so simple that the law firms just have a one touch in getting ready for that virtual hearing, if you will. They're not expected to do anything advanced, even though the platform offers a lot of advanced capabilities like David talked about, redaction, annotations, and things of that nature. They're taking a step at a time. Let's start with the basic upload capability, and then over time we will add in more functionality and train the users appropriately to do that. So that's a big best practice that I would say. The other thing, what David talked about in terms of documents and how documents can be viewed only by select people, there are best practices that we can bring forth, specifically as we're thinking about jury and witnesses, where we can apply security and practices to make that experience simple as well. Back over to you, Kendall.
Yeah, I think that phased approach is so important. And I think about a pilot that we ran for many months in Texas in Webb County County Court at Law number 2 with Judge Villarreal. And over the course of just, a few days, his staff was able to activate, 1,000 cases and get information out to the bar that did business, that had cases in his court, and really just start very efficiently and very quickly. And I know that he is proud today to say that he is 100% digital now in his court. Every hearing is done both remotely and then in person now that they're opening back up the courtrooms, but he has no paper coming in because he's able to leverage both e-filing, and then for documents that aren't e-filed, he's using the evidence sharing platform so that he can review those documents before they go into the record. And speaking of e-filing, Mahesh, can you speak a little bit about how the evidence sharing platform is a complement to e-filing?
Definitely. There definitely is some confusion about it. And if you think about how our court systems have evolved over time, e-filing, the best way to describe it is it is the virtual court counter. So you want to file a document to initiate a case or have a subsequent filing on a particular case, you go to the court counter today to submit that piece of paper. E-filing serves that need in that virtual/digital environment. It is the virtual court counter. Whereas evidence sharing is really enabling the court proceeding to move forward to consider other pieces of exhibits or evidentiary material that are pertinent to that particular case. They're contextual, they're not admitted yet, but as part of a hearing, a judge and the two counsels will come to a decision with respect to whether this is admissible or not. And that's where Caselines is unique and is a true complement to an e-filing, which starts with the case initiation, which starts with following due process from a filing perspective, whereas the evidence sharing really helps us conduct a contextual conversation with respect to coming to a decision on that particular case. Hopefully that sort of demystifies how the two come together.
Yeah. And I'm sure, David, you have examples of where the platform CaseLines has been implemented where e-filing doesn't exist. Do you want to talk about that experience a little bit?
Yes, certainly. What we've seen is that CaseLines can provide people who haven't yet had the ability to put an e-filing system in with a rough and ready e-filing system that allows parties to get all of the evidence into the court and in front of a judge very simply. And then most recently, we're taking that forward to help courts think about the problems they have with pro se and self-represented litigants, which are increasingly giving courts a problem. And we know taking up time from court staff, putting the CaseLine system in frees up some time for court staff to do things that are addressing more current problems. And at the start of October, we just released a new change to the system that allows a court clerk to invite a pro se litigant to put documents straight into the CaseLines court record very simply. All they need to do is receive a message sent to their cell phone, and from that text message or sent by email to their home computer if they want, they can just upload documents very simply. For instance, a document might be a bank statement, it might be a photograph, and now all the pro se litigant needs to do is simply receive the message from the court on their phone, take a photograph of a document, click and send it back to the court, and it will automatically be loaded into the file. So that's a really exciting change to support that type of e-filing activity.
Yeah, that's great. And talk about, eliminating any barriers to entry for the self-represented litigant. They're able to really just from their mobile participate and meet the needs of kind of their case without having the burden of learning how to use, the technology through a laptop or through a computer of some sort. It's all, facilitated, and they can participate directly from their cell phones or whatever mobile device. That's a really exciting enhancement that's coming. Are there any other enhancements on the immediate horizon, David, that you want to share?
Well, I think the next big step for us is around virtual juries. And, there's a lot of work going on with customers in the US who are now looking at being able to do a real virtual jury environment. And this is tackling two issues. One is, how do I deal with a jury that is physically present in the court, but we don't have any paper? We need to show everything to the jury. System can already do that. But also, how can we manage the jury when the jury are physically in separate places dialing into a virtual hearing? And those tools are now in place to allow courts to run completely virtual juries. That's exciting as well.
That is very cool. And talk about game changing. What a fast pace the entire court system is now evolving right before our eyes. It's very exciting. And, I happen to be involved in a jury process, and it's a great tool for us all to be able to use. So that's really exciting. Mahesh, what about kind of taking a larger step backwards or outwards? Where do you see the evidence sharing platform really sitting within the Thomson Reuters set of solutions, and where are things going now?
When you're talking about public safety, justice, and the courts, they all sort of are hand in glove, right? How can Thomson Reuters deliver an end-to-end experience, if you will, for all the various parties that are part of this ecosystem, from law enforcement to prosecution to the law firms and to the courts, so we can have a unified experience that brings together the entire story? Am I interacting with the right person? Do I have all the information that I need to make a proper and a timely decision? Can I have an integrated experience where I'm conducting, whether it is a virtual hearing or a physical hearing, in an extremely contextual manner? If you think about just those concepts, you can already see there are various other capabilities that we need to bring into this mix that make that experience very unified and make sure that it is secure and it is transparent to follow the due process the courts have already established. So Thomson Reuters is investing and innovating to address each of those concepts that I talked about. And over the course of the next 6 to 12 months, we are going to be coming out with capabilities that are going to answer those pieces: identity of individuals, contextual information to make better decisions. Can we have an integrated experience leveraging platforms like the video conferencing tool that we're on right now to make sure that all parties have fair access to justice? Back over to you, Kendall.
That's great. It's a very exciting time, and the pace at which the technologies are evolving for court technology is just remarkable. So I know I do want to address just a few questions that I've seen come in before we kind of move into our close in these last few minutes. One that I've seen that I haven't been able to respond to live yet is, how long does it really take to implement the ESP platform? Mahesh, do you want to speak to kind of time to implement?
Sure. The fastest time to implement can be a week. we have pilot courts that were able to take the solution. They defined their business practices, and with some minimal training, they were able to get up and running within a week's time. Not to say that it's going to be the case every single time. It does depend on the individual court, the scope of the implementation, but on average, you're talking about a reasonably sized court taking about 4 to 6 weeks to be up and running on the CaseLines platform. As you're talking about statewide rollouts and things of that nature, there's a little bit more training and business process alignment that needs to be done. That would probably be about 2 to 3 months, but you're not talking about any timeframes more than that.
Okay, that's great. So immediate efficiency is in the horizon if courts move to use the platform. That's great. Another one's come along, another question, David, I'll point this one to you. How does the system handle surveillance videos?
Surveillance video is very, very easy. One of the things that we're seeing a lot of interest, as well as the courts, is also law enforcement agencies and the DA coming to us and saying, can we use this as part of an end-to-end journey for evidence? It's very easy to upload surveillance video, also audio, 9/11 recordings, any form of evidence like that. And then we store it. We make sure that it is held secure for chain of custody purposes. And we make copies available for playback in the browser. And one of the things that people find very useful, as you saw in the demo earlier, was the ability to tab a point in a video so that in court, an attorney can take the judge and the jury straight to a particular point in the video, rather than spending time finding the right point, sometimes having to take the jury out while they go and find the right DVD player. All of that is gone. Now it's just click and off you go.
Okay, great. Another question we have is, how is the system deployed? Is it a cloud-hosted solution or is it a on-premise solution? I guess, David, do you want to take that one as well?
Yes, it's a cloud solution, and that has really delivered some huge benefits for courts over the last few months as COVID has come along. We know early on one of the difficulties that courts had was that their staff had never had any reason previously to work from home. So the systems weren't designed to make it easy to work from home. It was difficult to give staff secure access to on-premise systems, which is what most people had built. By being in the cloud, we'd already dealt with those security issues years ago, and we knew how we could move people into the cloud very quickly. So it's been a platform that allows people to get into the cloud quickly. They can carry on moving. We've also seen that recently there have been ransomware attacks, and there have been a few customers who've been attacked by ransomware in the courts. Those that have been in the cloud using systems like CaseLines have been protected from those ransomware attacks and have been able to carry on going without any interruption to their business processes at all. So we're now seeing the whole attitude to cloud is changing. People are realizing that almost certainly it's going to be a key part of the mix for delivery of court solutions in the future.
Yeah, that's exactly right. And I'll just say that we also at Thomson Reuters have a case management solution, C-Track, and we're seeing more and more customers even deploy their entire court management or case management solution to the cloud as well. So you're right, the security that the cloud offers is so much more significant than on premises, especially with the world that we're living in today. So it's an important attribute. The last thing that I'll point out then of one of the questions that has come in, Mahesh, I'll point this one to you. Does someone have to use a specific video conference system in order to use the evidence sharing platform?
Not at all. Not at all. That's the beauty, right? The video conferencing platforms that we've all gotten used to with COVID, everyone and personally started using Zoom to have family and friend calls. Same thing. Courts have adopted Zoom. Courts have adopted WebEx. Some courts are using Teams. There's BlueJeans. There's a number of different solutions out in the marketplace right now that provide video conferencing capability. And given that CaseLines is a complete web-based solution, there is no need for a very specific solution to get CaseLines to work for your particular court. It is very straightforward, and the tools already provide the sharing capabilities that we just natively take advantage of.
That's great. So video conferencing system agnostic, and I think important is that this is truly a tool that transitions into the physical setting as well. So even as we get out of this virtual conferencing experience and we move back into the courtrooms, this tool is just fundamentally what can be utilized to facilitate digital hearings, not necessarily remote in every instance. So I think that's a really important piece. So just a few kind of customer points as we close out the session today. Again, many years of experience in the market providing the solution, as David has outlined with the UK and South Africa type implementations, with a high degree of satisfaction. David, are there any closing remarks about kind of customers' experience in your international deployments?
I think the thing that has been most obvious to us is the degree to which judges, lawyers, and court staff all enjoy using the system. Very often when you try to roll out new software, there's somebody who wins and somebody who loses. But our experience overall with CaseLines has always been that there is something in it for everybody. There is some productivity gain for the court staff, there is some ease of use for the judges, and there's some benefit for the lawyers bringing the cases to the system. So we found that people have been very, very enthusiastic. It was quite heartwarming to read the Twitter feeds when the Ontario courts announced that they were using the system, because within minutes there were people putting really, really positive Twitter messages out there. And then they announced it was going to be the civil courts that went first. And before an hour had gone by, the family courts were jumping in and family lawyers saying, well, but what about us? We want this too. That was really, really exciting to see. But my favourite comment, and the thing that I think really sums this up, is the Lord Chief Justice of England and Wales. He's the most senior law lord in the entire country. And he stood before the British equivalent of the Bar Association, the Law Society of England and Wales, and gave a speech and described the system as a godsend to lawyers. So,
and it doesn't get much better than that. I do reflect on someone that I respect a lot, Richard Susskind. He speaks about how at the end of the day, no one wants to go to court. So finding ways to help litigants have their day in court in the most efficient and expeditious way is really what we're trying to solve for. So it's tools like these that really, help deliver access to justice, help us get through the process, because no one wants to be in court. So whatever we can do to minimize, the angst around that is what we at Thomson Reuters are really excited about. So I just want to, again, thank you to Mahesh and to David for joining me today in our roundtable discussion. Thank you to everyone at the National Association of Court Management for, again, allowing us this opportunity to present to you all today. We hope that our audience is eager to learn more. So we would invite you to not only visit our virtual booth, but also visit our website at tr.com/evidence sharing. From there, you can learn a little bit more and request an appointment or a demo with one of our specialists. Again, we'll be responding to the additional questions that came in that we weren't able to get to live, so I appreciate that. And with that, we will say adieu to you all, and please be safe and have a great day. Thank you.
Thank you.
Goodbye, everybody. Thank you.